20.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Today's courtroom session quickly turns into a dramatic clash involving allegations of domestic assault, unpaid child support, and a father trying to rebuild his career while facing mounting legal pressure. On one side, a mother claiming she's been left to raise 2 children alone without support. On the other, a man arguing he's finally getting his life back on track with a new law enforcement job. But now a snowstorm, a training academy lockdown, and a looming contempt case threaten to derail everything. The judge must decide, should the case be delayed because of weather and job training, or should the court move forward to hold someone accountable? This hearing may look routine at first, but watch closely, because within minutes, the tension rises, accusations fly, and the judge makes it clear that excuses may have run out.
25 CV 133 Andrew Turner versus Abigail Saints.
Microphone listen.
That got continued.
Oh, it did?
Yes.
Okay.
Yeah, I'm sorry.
That's
The
okay.
other attorney,
You can just keep it.
Scott Daniel notified me that it's a motion for default.
Okay.
And Scott Daniel notified me last week that he had been retained and filed a notice of appearance. And I thought we had called yesterday and said that Mr. Daniel was
Not a problem. It was continued, so we'll just take it off the docket.
right. It was a motion for default, and now has an attorney. So
2025 PR 96 regarding the estate of Alveda Hines by Matthew West.
Good morning.
Matt West, Madison County Bar.
I read through the file. This is just a motion to bring the real property into the estate because there's no assets with which to satisfy TennCare's claim. Anybody here opposing this motion? No opposition. The motion is granted. Well, order. Yes, thank you.
2023 CV 216 Talisa Hinton versus Stefan Hinton.
That's here for filing here. Mr. Roberts and myself. I kind of filed a quick motion to continue yesterday. I'd like to take that up. We'll check up.
All right.
Here, Mr. Hinton's on Zoom, I believe. He should be waiting.
Bring him in if he's not. All right, Mr. Hinton has been admitted. He has not turned on his camera, but I'll ask him. There he is. All right, thank you.
So, Judge, last time we were in court, you instructed Mr. Hinton to get a job, which he has done. He has been employed now with the Montgomery County Sheriff's Department. He's at the training academy now to get post-certified. He had arranged to have today off. He was going to get off last night, get here, drive back, be back to the academy Wednesday morning, whatever that took. It's in Greene County, Tennessee, and unfortunately, we've had quite a snowstorm. I think they're around 18 inches somewhere there. Normally, they get to go home on the weekends. His testimony would be they got on lockdown this weekend. Their director wouldn't let anybody leave, and that's still kind of in place. Fear is, I guess, if they leave, they'll get stranded, miss more time, and have to redo the entire class. it's just a victim of we're a victim of Mother Nature today, and with the snowstorm the way it is, I really don't want to try a case with him on Zoom. I like to have my client present at the table so that I can speak with him.
Here's where things start getting interesting from a legal perspective. The defense is asking for a continuance, basically a delay in the case, arguing that the snowstorm and academy lockdown physically prevent the defendant from appearing in court. Now, judges often grant continuances for legitimate reasons, but timing matters. This case already involves allegations of unpaid child support and previous contempt issues, so the court is weighing more than just the weather. And here's the real question for viewers. Is this truly an unavoidable situation, or does it look like yet another delay in a case where the family has already been waiting months for accountability?
So I would ask that the matter get reset for another day. I've shared with Ms. Roberts a letter from the director of Law for State that I could give to the court. That kind of explains the situation that he's in. It does state that, he's on lockdown as of January 31st. So there's really just no way he could be there. He would testify he actually drove up there in the Montgomery County Ford Explorer, and it's there. He said it was doing horrible in the snow, and he was trying to get out of Montgomery County to get back to the
So according to this, he's going to be basically involved in that until March 13th.
That I thought he told me last night, March the 3rd, maybe March 13th. Yes, something like that.
He says he will be a student in the training academy from January the 12th to March 13th. And Ms. Roberts, any response?
Yes, Your Honor. Again, we were here. Mr. Hinton has of course, started this case out with an order of protection due to domestic assault. And then he was ordered to pay child support, which he utterly failed to do and had to have a contempt petition came up. Now he's in contempt. This will be, I think, the third stint of contempt where he's failed to pay child support since October. Your Honor, this is a man who left his family, started having a relationship with a paramour, got her pregnant.
This is the one with the cheerleader.
Yeah, so he started having an affair with his little girl's cheerleading coach, who was friends, that has now utterly destroyed that relationship. And now he's decided, I guess his stepfather, who's here, who's come to testify, who is with the Montgomery County Sheriff's Department, assisted him, even though he has an order of protection for domestic assault, to be employed as a peace officer. And the fact is, this matter was set at least 2 to 3 months ago. When we were here on, again, his other failure to pay, he lost his job because of fault and just quit paying child support in October. My client has been here with the 2 children without any support with this man. Then I got an email from Mr. Hawley yesterday stating that Mr. Hinton was on lockdown at the training academy, the post training academy there in the
lockdown is because of weather.
Well,
it seems to say both ways, that he's on lockdown because of the weather, but also then they're asking for him not to be able to miss any further classes.
Well, and that's the thing that bothered me, and why, I was out of the office yesterday afternoon after I got this, and as I read this letter from Director Stansel, it says, due to the requirements of the Tennessee Peace Officer Standard and Training Commission, requiring basic training of police officers, if Mr. Hinton were to miss any training classes during these dates listed above, he would be required to return during the next academy to make up the missed classes in order to become a certified officer. So why couldn't he just do that? He says he made arrangements. Mr. Hawley's office told in an email, Ms. Bobby said he had made arrangements to be off.
Well, I want to hear from Mr. Hawley about it, but it does seem to me that there's a distinction between the weather lockdown, which I certainly understand, considering I took my life in my hand the last 2 mornings and driving on my road, the Ridge Road, which is completely ridiculously in bad shape, and made it here. But that's one thing. The other is, whether or not he can make up these training classes, because I have February the 19th and 20th available to hear this case in its entirety.
Well, and my scenario is, Judge, is I mean, it's at some point in time, Mr. Hinton needs to quit being the focus. Mr. Hinton left his family, put them in a situation where there was an order of protection. He failed to support his family. He moved on with another one, had another child out of wedlock, came before this court and wanted to have this whole, my client was put their child in therapy. She's the one that's carried them to therapy, done all the stuff. She's the one that's done without, because Mr. Hinton just needs to find himself. And I mean,
I understand that, and I agree.
It's frustrating that Mr. Hinton thinks that he's the center of everybody's world.
Which is why I'm offering you the weather is one issue, and I do understand that has been a problem. The reason that I'm suggesting it for later in the month is so that we can address those issues, and he'll just have to make up a class.
Right. And what days were those?
19th and 20th of February. I was supposed to be trying a first-degree murder case that got continued. The backup case was a week-long civil personal injury case, and it got settled. So I have the 19th and the 20th. I've already given out the other dates, the 17th and the 18th. Those have already been given out. So.
And I'll make myself available.
19th or 20th. I'd rather do it on a Thursday.
Address 4.
Yes.
Again, we're ready today, except for Mother Nature.
You should be ready on the 19th or the 20th.
Well, if he's here, and again, this is the problem with not having a client here. I can't turn around and ask him a question.
I'll take a recess in this case, or give you an opportunity to talk to your client. But I'm of the opinion, based on this letter, that he can make up the class that he misses if we're here this case on the 19th. I'm giving him the benefit of the doubt about the weather, because it is bad, and it's just a question of whether or not he's, the only situation is, in my opinion, this case needs to get heard and disposed of, and that this is not Mrs. Hinton's problem. It is your client's problem. I'm giving him an opportunity to be heard in person on the 19th.
And I'll definitely address that with you. The concern, of course, everybody wants him to get a job. Everybody wants him to pay child support, wants him to pay spousal support. There's been a contempt filed, and I filed a motion to alter or amend the child support and the spousal support some time back to have it heard with the original case when he lost his job. We were here asking for, if the court will remember, some additional days of visitation to kind of increase that a little bit, to get some unsupervised and things of that nature. The court put down an order, which I'm still, I think Ms. Roberts has done an order that was due, and I've got to do this one. You did kind of increase that a little bit, but one of the things you told him was you would not give him any weekday visitation because you expected him to go out and get a job. And of course, he's done that. And, if we set this, and I'll talk to him, I'm just concerned that if he misses the 19th or the 20th, based on everything going on now, and he can't do the class, then we're back in we're in the worst shape that we were in before we ever got started. He's trying to correct everything. And if he gets kicked out of the class because of, having to hear that on the 19th, then we're kind of in a worse position than it would be if we would have it heard just 30 more days.
I understand that.
I can have a chance to talk to him.
I've given you 2 days. Case will be heard on one of those 2 days. The 19th would be my preference, but I can do it on the 19th or the 20th. But it's going to get heard this month. So
I have the 19th available. I've got a mediation on the 20th.
Reset for the 19th. You can talk to your client about what arrangements he needs to make to be able to participate. He would obviously be missing classes today to do that. He's not. So now he can go to those classes, and then I would think they will give him the benefit of the doubt to make up a class. According to the letter, he can make the class up and become post-certified. My understanding is there is a distinction between having a job working for the Montgomery County Sheriff's Department and getting post-certified. What he's trying to do is get it post-certified. There are many officers that work for sheriff's departments around here and police departments that are not post-certified. It's a step forward in his career, but it is not going to keep this court from hearing this case on the 19th. So he needs to make whatever arrangements he can do. It looks like he's shaking his head in the affirmative that he can do that. So I
need to talk to him. Can you do that? Can we just ask him? Is there a need for us to
do
that?
I'm setting this case for the 19th. I assume you can make arrangements with your employer or with the training there to be available in person here on the 19th, correct? All right, he's muted, so he
Okay,
can't.
fair enough.
He says he can be here, so the 19th it is.
19th it is.
9 o'clock that morning, and this will be the only case we will be hearing.
Outstanding.
And Your Honor, Mr. Holly accepted the service on the motion on the petition for contempt.
Everything that we've got in this case needs to be heard on the 19th. All right,
Well, can we have the contempt heard at the same time? We're gonna have to bifurcate. That's my understanding.
you have to, if it's a criminal contempt, it has to be bifurcated. If it's civil contempt, it can be heard with a divorce.
I think it's so. I think it's so. Okay, that's all you said. All right, thank you, Judge.
Then we'll see you on the 19th. Mr. Holly, if you need to talk to him, you can call him while.
I will. I don't, if he's okay with that, then I don't have a need. I just wondered if he had an issue with it. I wanted to make sure we got.
It's a civil contempt, Your Honor.
Yeah, I thought it was. Okay, that's not.
Thank you, Mr. Hinton.
Thank you, Judge.
All right. In the next case,
Running late.
all right, Christy Thornberry versus Tristan Thornberry is a motion to dissolve a no contact order, and that I'm told Miss Miss Duke is involved in that along with Mr. Holly. So, and I'm told she's running late. So
That's what I understand. I'm kind of texting with her back and forth, but it's actually a motion to amend the 2024 order. It's a handwritten motion he filed again in jail. You've already heard one of them. So it's just a motion to amend that order. It's not necessarily to dissolve the contract.
well,
Part of the amendment.
Mr. Thornberry, I think, is here, so he's no longer obviously incarcerated. So
He's not, Your Honor, and I have filed on behalf of the paternal grandparents, a grandparent visitation case when Mr. Thornberry was incarcerated. And so that's not part of this. They're not-
paternal or maternal? Paternal.
I represent paternal. And again, that's not, these haven't been merged. But again, there is a companion case that will be affected by what the court does in this matter. Because again, the father's visitation, if it's altered, it affects the grandparent visitation.
Well, let's take it one step at a time, but we'll first of all, I'll step off. We'll take a recess and allow Ms. Duke to, do we know where she is? I know she has some issues that she needed to address this morning. So
ETA would be between 9 and 11, so I got it. I'll call her right off the bench.
she'll be here between 9 and 11.
That was what I asked her what her ETA was. She goes, it's somewhere between 9A and 11A. She's waiting on some.
That's fine.
So I get it.
Been there and done that.
Yeah.
So I'm going to give her the opportunity to be here, but obviously it would be better for us to know for sure what time, but just let her know we're waiting on her.
I'll give her a call. Thank you.
This hearing shows how family law cases can quickly become a mix of personal conflict, financial responsibility, and courtroom logistics. The judge ultimately refused to delay the matter indefinitely and set a firm court date for February 19th, making it clear that the case, along with the pending contempt allegations, must finally be addressed. From a legal standpoint, the key issue moving forward will be whether the father's recent employment changes his financial obligations or whether the court will focus on the months of unpaid support and prior contempt findings. Judges often prioritize the stability of children in these cases, which means accountability tends to weigh heavily in the final decision. But what do you think? Should the court prioritize his attempt to rebuild his career or focus strictly on the missed support and past behavior? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.